We're going to begin today by taking up this case, People of the State of Michigan versus Kelsey Jacqueline Sim. We are here today for a sentencing in this case.
This was a difficult case, Judge, insofar as, in my interactions with Miss Sims, she's been focused on rehabilitation. Unfortunately, Mr. Blazak report does accurately summarize some of her conduct while out on bond, while attempting the rehabilitation. And unfortunately, I think the court is probably too familiar for its own liking in terms of the ebb and flows of people that battle addiction. Talking to her recently in preparation for today's hearing, she remains focused on that. She's once again made contact with the Sunrise Center. She does inform me she's serving a separate sentence for some misdemeanor offenses through Wexford County. Her release date is February 8th, 2026 on those offenses. She's hopeful that she will have an opportunity to re-engage in rehabilitative substance abuse services through Sunrise Center. I'll just say that she's been very cooperative with members of law enforcement since she's been detained in the local jail on some other matters. My understanding is that cooperation was appreciated. And regardless, ultimately, she understands that, she's got a checkered past. This is now an additional felony conviction. And anytime you start trending towards a total, more or less hit count, if you will, approaching 20 prior convictions, that's certainly concerning in terms of her ability to remain free should there be additional contacts with the criminal justice system, certainly in the felony land, as her guidelines would go clearly away from any type of presumptive no jail sentence, to perhaps consider keeping her there or thereabouts with her current release date of February 8th, 2026. Thank you, Judge.
Mr. Diego, she mentioned that there were some other issues that she's had over in Wexford County. Did she enter pleas or something? Was that taken care of in the district court over there?
My understanding is yes, Your Honor. She is currently serving time for a malicious destruction of property charge and perhaps an attempted R&O as well.
All right, thank you. Mr. Denhouse.
Thank you, Your Honor. The underlying incident occurred back in December of last year. The defendant was on supervision at the time. There was a compliance check, and she was found with some narcotics.
It was not.
It's a tramadol.
Right. He just said that I was on supervision, and I was.
Oh, I'm sorry.
I was at somebody's home who was on supervision.
I got it.
I'm sorry for.
It's okay.
Okay.
I think it's all right. Go ahead.
I appreciate it. It was a compliance check. I perhaps misspoke for another individual, so I apologize for that.
It was Mr. Ealing.
In any event, I accept the correction.
Which, by the way, Mr. Blazak, when you put in a person's name right after their address, if their address ends with the word drive and you just put DR, it looks like you're saying that Mr. Ealing is Dr. Robert Ealing. I had to keep shaking my head. I'm like, I'm pretty sure I've never heard of him as a doctor. All right, go ahead.
We would never penalize someone for exercising all of their rights and contesting all matters. We would never consider doing that. But to the defendant's benefit, she acknowledged that she did have narcotics. She pled guilty. Also, when the bond violations came out, she also acknowledged the difficulty that she's been having. So I think that can be stated on her behalf. She has been struggling. There has been a series of bond violations. I know the recommendation now is for a straight jail sentence. We understand the reasoning why that recommendation exists. We support that recommendation, and we would leave it to the court for the exact term of any additional incarceration.
All right, thank you. Ms. Sims, you have the right to make a statement if you so choose before the court issues a sentence. Is there anything you wish to say today, ma'am?
Your Honor, I would just like to say that your mercy was not extended in vain. I did happen to, I had 1 week left of treatment, and I got into a verbal argument, which caused me to be released from the treatment. I managed to stay clean. I'm clean to this day. I did not indulge back in drugs. I started going to a revival center and became part of the celibate recovery. I maintain a job now. I also have been going to church occasionally with the owners there who are part of First Presbyterian in Cadillac. So I did make some significant changes, although I do take accountability for you extending that mercy to me and me failing. Like that was it's. I still hold that as a reminder in my head today that that I don't want you to think that your mercy was extended in vain. I'm just grateful for your time today, and I.
Today, the Michigan court is sentencing Kelsey Jacqueline Sims. The defense highlights her focus on rehabilitation, but a report reveals repeated issues while out on bond. She's served time for other misdemeanors and hopes to re-engage with substance abuse programs. Despite cooperation with law enforcement, her history is concerning, approaching 20 prior convictions. The judge must now consider whether she can truly remain free or if jail time is necessary. Sims acknowledges her past mistakes and accepts whatever sentence the court sees fit, emphasizing she's stayed clean and is trying to change.
Substance use and treatment, it now says no substance abuse history found for the defendant. And now I start scratching my head wondering, well, geez, why wasn't there a list of drugs on CFJ 145 page 1? And then I wonder, why does the compass score and comments talk about her having a drug abuse problem? And then I get back to this page and it says, well, she doesn't have a drug abuse problem. And then I wonder, well, then I go to look at her criminal history. In 2013, she had a conviction for morphine. In 2016, she had a conviction for fentanyl. And in 2018, she had a conviction for meth. Especially when somebody has been gone for 5 months, you need to do an updated PSI, because it also doesn't include the fact now that I know she's got other convictions while she's been on my bond. From the sentence, I wrote down the sentencing and the story told here are incomplete and inconsistent. Because why would I, or this court, or any court, send her and allow her to do rehab and then find out she violates rehab and to find out she needs rehab when the report, half of it makes it sound like she has no drug problem or drug history? So there's a lot here that this report is not done well, and it needs to be updated. Now, Ms. Sims, we've already talked a little bit or talked around it. Your performance on bonds has not been good, and you have left programming when the court lets you go there. When again, you talked about it being grace, and I appreciate that. That's what it is. It's a grace to allow a person the chance to go prove themselves. Well, in here, you were removed from one program. You revoked your waiver so community corrections couldn't find out where you were or what you were doing. And you failed to keep community corrections informed of your whereabouts. And you were not cooperating well with your PSI, which may contribute to the inaccuracy of the report. So let's take a look here at the crime. The crime was relatively minor. You had, it looks like a pill or two of the tramadol, and you called it medication for your dog. I don't believe that's what it was. I don't know of many dogs getting prescribed tramadol, but the fact is, if you want to take that, then my thought is, well, then your problem, your substance abuse issue is so strong that you're willing to take dog medication. But we all know that tramadol is often used for adults in certain circumstances. So then I looked at the history. Back in 2008, she had a juvenile, in 2004, a juvenile history, adjudication 2007, and that was, you were discharged on April 15th of 2008, and you made it a little over about a year and a half before you started picking up charges as an adult. Between your 2009 conviction, actually you had 2 of them, and they were 1 month apart. In November of 2009, while you were on bond for one of the previous ones, you picked up a conviction. And it looks like you had paid all your fines and costs in that case, and there was an active warrant for you out of Manistee. Well, when that case was done in August 10th of 2010, you were back in front of a court within 2 months. No, that's one bond violation, failure to appear. And then you had 1, 2, 3, 4 different probation violations. In fact, when you were sentenced on April 6th of 2011, you were back in trouble in 2 weeks. Then between entry 5 and 6 of 15, you did have a gap of 2 years, and that's where we saw the morphine come in. And then probation was revoked in that file because you were violating probation quite quickly. Then, after being off of probation for 4 months,
The judge dives deeper into Sims' history, noting inconsistencies in reports and bond violations. Previous convictions for morphine, fentanyl, and meth show a long pattern of drug-related offenses. Multiple probation violations and repeat criminal behavior raise serious doubts about her ability to follow the law. Even minor offenses, like possessing tramadol, highlight ongoing struggles. The court's message is clear. Rehabilitation is a chance for change, but repeated violations show a worrying pattern that cannot be ignored.
on it, you violated bond and picked up new charges. But when the court allows somebody to go to rehab, it does so because it cares and wants to give rehab. But I also do it to see how people behave and whether or not they're going to continue their previous patterns. That's a problem. So what I see here is 20 years of the same types of almost 20 years of the same kinds of problems: violating bond, violating probation, acts involving drugs, acts involving crimes of dishonesty, acts involving violence. Well, in this case, the court assesses the standard $68 state minimum fee, $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. DNA was already available. There will not be any supervision. So there's no supervision fees. And the court sentences the defendant to a jail term at the top of the guidelines, which is 330 days with 35 days of credit. I do so because I've already covered all the reasonable grounds. Every opportunity or grace has been provided to you, and you've thwarted them over and over and over again. So, nope, it's all right. That's the sentence. There's nothing you're going to say that's going to make it better.
Just a note to another to continue to stronghold my treatment.
Yeah, well, they have people who come to the jail. You're not going to be placed on probation. You're telling court, just as Mr. Nago said, you're at that level where next time you're looking at presumptive prison cells on felonies, at least for drug charges. And you've had the opportunities and you rejected them. And it's your issue, not mine. This has nothing to do with this court. That's the sentence of the court. Have I missed anything, Mr. Blazak?
Is that making it work really?
Probably don't. Mr. Denow? Madam Clerk is going to bring out to you, ma'am, 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt to the copy of the document. This document tells you that you have the right to file an appeal in your case. Based upon the plea, any appeal must be done by filing an application for leave to appeal and not a claim of appeal by right. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Any questions, Mr. Niegos?
I got it.
All right. Thank you all very much. Ms. Sims, I do want you to use your time effectively. I'm hoping that the words I choose, not that everybody pays attention to them, sink in. You're at that level now where there is nobody else.
Tramadol, so
I'm sorry?
it just upsets me because it was for my dead dog's tramadol and getting the county.
No, hold on.
Yeah,
You're not.
that's upsetting.
Just a second.
I didn't even have it in my possession. And because of my past history from 12 plus years ago. That's what's upsetting.
Yeah.
I'm losing my job. I'm going to lose everything
Because of what?
because of my past history.
Yeah.
People change. People change, Your Honor. And I have changed. A past history. The fentanyl charge wasn't even a fentanyl charge. I got larceny in a building.
Okay.
This is for past history. And I had my dead dog's tramadol. I don't even know how it's illegal for me to have a prescription of my dead dogs anyways. This whole thing makes no sense to me. I'm just in shock right now.
Okay. I understand that you're just in shock, but this is not just because of your past history. This is because your pattern, and because in your pattern, you've continued to demonstrate. You continue to violate bond. You continue to violate
Give
all.
somebody a county
You're
year.
going to let me talk. Okay, hold on.
I don't really, I mean, at this point in time, it don't matter anymore. It doesn't matter anymore. You made your decision and it
Yeah.
doesn't matter. You just ruined my life. I was starting to do good. I was starting to have a good job. I had a good support system.
Ultimately, the court sentences Sims to 330 days in jail, crediting 35 days already served, along with fines and fees. No supervision will follow. She must face the consequences directly. The judge stresses that every opportunity and act of grace was given, yet repeated violations forced this decision. Sims expresses shock and frustration, claiming her life and progress are ruined, but the court points out the pattern is the problem, not just her past. The ruling underlines that repeated violations of trust and law cannot go unpunished, sending a strong message about accountability.